Thank you very much. Right, we're reconvening, and we now move on to our second panel of witnesses. We've got Right Honourable Frank Mulholland, QC, Lord Advocate, and Katrina Dalrymple, Head of Policy Division, Crown Office and Procurator Fiscal Service. Good morning. It's still morning, yes. Lord Advocate, do you want a brief opening statement as I offer to the Lord President?
Yes, thank you, Chair. Firstly, good morning to everyone. Just a few opening remarks. I suppose the committee is concerned with the proposal to abolish corroboration, which I think has exercised most of the debate on the criminal justice bill. So if I could say a few opening remarks about that. My view is I support it, and I support it for a particular reason. I see and prosecutors see the effect of the rule of corroboration on certain areas of criminal offending, in particular sexual offending, including rape and domestic abuse. It's particularly acute in relation to those areas of criminality. As women and children are and very much the majority is victims in that area of criminality, I see the effect of corroboration as being disproportionate in relation to women and children. So I support the abolition of corroboration for that particular reason. Further, there's a number of matters which have been raised by speakers to this committee. If I could deal with two of them in particular, and of course I'm quite happy to answer any questions that members have. But it's been said that the abolition of corroboration is particular in relation to increasing the conviction rate in relation to rape or sexual offending. I've never seen it as that. I've never ever said that the abolition of corroboration was all about increasing the conviction rate. I see it as access to justice for the victims of domestic abuse, rape, sexual offending. And it seems to me that that is something which any modern criminal justice system should have. It seems to me that there's a class of witnesses, of victims in these two areas of criminality that are denied access to justice for in particular the requirement of corroboration, the legal requirement of corroboration. If I could just illustrate this with some figures. Firstly, in relation to domestic abuse, 2012-2013, 2,803 charges of domestic abuse could not be taken up because there was insufficient admissible evidence. And that is, I would suggest, a matter of real concern that we are not giving the possibility, access to justice for certainly a sizable proportion of victims in those charges. So that's domestic abuse. The second one is in relation to rape. I asked yesterday if policy could give me the figures, say in the last 2 years, of how many cases or charges of rape that could not be taken up as a result of insufficient evidence. Although this is not statistically robust in the sense that it's not a full double-checking exercise, I wanted to have an indication of the type of numbers of charges that couldn't be taken up because of the requirement of corroboration. And it's about 13% of charges, rape charges, reported to the Crown. 100, I think, in 1 year and 70 in the second year. So it's 170-ish over a 2-year period. So I would suggest that that is a real cause for concern for anyone who's interested in delivering justice in Scotland. I should add that it's not. You have to ensure that there's fairness in any criminal justice system. I accept that, and all Scotland's prosecutors, certainly that I work with, are imbued with that notion of fairness. I can speak in due course about the checks and balances, and no doubt that I'll be asked about that. But the second matter is a suggestion that if corroboration is abolished, then the police and prosecution will only look for a limited amount of evidence, will not look for any additional evidence that may be there. I would have to refute that suggestion. If that is correct, if that suggestion is correct, then you would expect the police and prosecution to stop it currently at corroboration, 2 sources of evidence. They don't do that. We are under a duty under the Human Rights Act, under the European Convention of Human Rights, to deliver effective criminal sanctions, which includes an effective investigation, effective prosecution. There's a raft of case law, in particular a case Smith against the Majesty's Advocate in 1952, which sets out under common law the duties that the police have. I think the Chief Constable's already commented that won't happen. It certainly won't happen under my watch as Lord Advocate, and the notion that you would wish to bring cases with limitations on the amount of evidence that could have been available, and you would want to present that to a court, to a jury, is a notion that I don't subscribe to. So other than those 2 opening remarks, I'm happy to take questions from members.
Thank you very much. It's very useful. Elaine, followed by Christian, followed by Alison, please.
First of all, Lord Gill had advised us that in terms of the views of the justiciary, he had actually surveyed the justiciary about their views on the removal of corroboration, and all but 1 were opposed. Has a similar survey been undertaken with Procurator Fiscals in order to ascertain the views of the people on the ground, as it were?
No, not in the sense of surveying all members of staff of COPFS. No, we haven't done that. What I can tell you is that at the time of Lord Carloway's review being published, we had quite an extensive meeting in the Crown Office, which was attended by all the senior civil servants, or most of them, most senior civil servants, procurators, fiscal, including the 3 federation heads, the Crown Agent, the head of operations, the deputy head of operations. And we had quite a robust chat about it, about what the Crown's position in all this was. And at the end of that meeting, I didn't detect any sort of dissension amongst the leaders of COPFS. So the answer is no, we didn't have a full comprehensive survey, but that was an indication.
Yeah, it's not the view of the service overall, then it's a view of senior people within the service in terms of...
I think that must be the case, yes.
Yeah. Can I go on to really the effects on victims, because obviously that is, I feel like, the primary consideration in terms of the suggestions. You say that you don't think there would actually be a larger number of successful prosecutions, and this is about access to justice. I just wondered, in terms of the victim who goes to court, either who doesn't get to go to court now, and there's no longer the view that it isn't because there was corroboration, that's just because we didn't believe you. Or if somebody goes to court and the jury then doesn't believe them, there are all sorts of reasons why people don't believe women when it comes to domestic violence or rape. It's about prejudices amongst the jury and so on. What is is that not going to have an even more deleterious effect on the victim, that they've gone through all that process, and it's her word against his, and at the end of the day, the jury doesn't believe you, and you basically are being perceived as having been lying? Is that not even worse for a victim than being told that they can't go to court because there's no corroboration?
Well, I'll answer it this way. In all my time as a prosecutor, and I've many years' experience, and I've been involved in many difficult conversations with complainers in charges of sexual abuse and rape to explain to them why we cannot take the case up. I've never known anyone to express thanks for not being able to take up the case. The contrary, in my experience, that they wished the opportunity for their version of events, their account to be heard in a court of law, with the possibility that the jury, with the burden of proof and all that, all the protections, would reach a verdict on it.
Wouldn't, admittedly people may not thank you for not taking the case to court, but could it not be even worse if you went to court and then were not believed once you got there? You know, that actually
Well,
we'll go through all that process and then you're not believed at the end of the day.
I'm not saying there may not be some validity in what you say, but all I'm saying is from my experience in having these difficult conversations, I've never known that sentiment being expressed. Can I just to take your point one stage further? If, and it's a matter for the Parliament, if corroboration is abolished, the prevailing view amongst procurators fiscal is it will lead to much more difficult conversations with complainers' victims, because rather than say, well, in law there's insufficient evidence to take the case up, what you'll need to then do is you'll need to explain the reasons why the evidence is not credible or not reliable, and that will be a much more difficult conversation than explaining to a complainer, a victim, that there's insufficient evidence. But we don't shy away from that. We think that as a point of principle, that to give greater access to justice for victims, in particular victims in two areas of criminality I spoke of, we think it's the right thing to do.
Christian, followed by Alison, please.
Thanks very much, Governor. Lord Advocate, good morning. Just going back into the access to justice in your opening remarks, you made your point very clearly, and you give us a lot of statistics. I'm not very keen on statistics. Sometimes statistics doesn't tell you the whole stories. I've seen in your supplementary evidence that you give us a number of case studies. Would you like maybe to develop one of those and telling us more about it?
Yeah, I mean, we thought about what these are real cases. We've anonymised them, and there are many more. I mean, I can speak from personal experience about the effect of CADA, because this is where it's most acute. Prior to CADA, in a rape case, you had fairly common. You had the victim complainer stating that she was raped by a named person. Now, the requirement of corroboration requires us to corroborate the crucial facts, and in a charge of rape there are three crucial facts. Firstly, you need to corroborate penetration, you need to corroborate lack of consent, and you need to corroborate mens rea, the accused's intention. Those are the three crucial facts in a charge of rape that you have to corroborate. Now, we know that in many rape cases, it goes back to Elaine Murray's point about the dynamic of this type of offending. It is fairly common, we refer to it as counterintuitive, fairly common for victims to think about whether or not to report these cases to the police, an allegation of rape to the police. They might want to think about it, they might want to talk about it with their family or their friends. It might not dawn on them. They may be unsure as to what precisely has happened. And there is the concept, a fairly common concept of delayed reporting. That's normal behaviour, we're told by the experts, and in rape prosecutions we will explain that to the jury. In pre-CADA type cases, during interview, it was fairly common for an accused person to say, yes, we had intercourse, but it was consensual. Now, in those circumstances, you have corroboration of penetration because you've got the complainer's evidence that she was raped, penetrated, and you have the corroboration from the accused's statement under interview by police officers. Now, post-CADA, the effect of CADA in many of these cases is that accused persons are saying nothing on advice. And I'm not being critical of that option being undertaken. That's just a fact that in many of these cases you don't have that source of evidence now. So the effect of CADA in many rape cases is that you're not having corroboration of penetration, because by the time it's reported, forensic opportunities are lost, they're gone. There's no point in taking intimate samples 1 week, 2 weeks after the alleged rape, and you won't get corroboration from that source. So we're seeing, as prosecutors, that in many rape cases where pre-CADA we would have had sufficient evidence, we're not now, and we can't take them up. And that, to me, seems a matter of real concern. And there's other examples. For example, I'll give you another example of one that I dealt with about 3 weeks ago. I'll anonymise it. And Margaret Mitchell, I think, I've heard Margaret Mitchell speak on Murov and the sort of extension or perhaps the redefinition of Murov. But one thing you'll never get away from in Murov is it requires 2 victims, 2 complainers. Now, I had a case where 2 sisters who had been horrifically sexually abused as children over a period of many years by a relative, a member of the family. The girls were told that no one would believe them if they spoke up, that no one would love them if they spoke up. So they didn't speak up. But eventually, as adults, they got the courage to speak up and make a complaint to the police. Now, the reason why they made a complaint to the police was quite simply that they were concerned that a relative had access to children of their age. Now, we took the case up. We indicted the case in the High Court, and we were prepared to proceed to trial. But one of the complainers, one of the victims, mentally could not go ahead with it. We tried to support that victim through the process, to give her as much support as was necessary. We got medical reports on whether or not it was detrimental to her health. But at the end of the day, we couldn't force that woman to give evidence. And the effect of that meant that the whole case fell, because it was a Murov case. And that, to me, is something which this Parliament, this committee, public at large should be concerned about. So, and I make the point, which I think is a good point. I respect, people in the legal profession, their views. I respect the judges' views, police officers, everyone involved in the criminal justice system and beyond has an opinion on this matter. What they are not seeing the cases which cannot be taken up because of the requirement for corroboration. And it's police and prosecutors that are seeing this class of case. And one other matter in relation to the abolition of corroboration and the effect on women and children, the disproportionate effect. I'm saying that. I've heard others say it. I've heard others oppose it. But it should be a real matter of concern that United Nations Committee against the discrimination against women in a report published this year, in July of this year, supported this and called for the abolition of corroboration. So I would suggest that that's a powerful voice as well.
I think I have to say now, I think I say on behalf of the committee, we would wish to see these prosecutions being successful. We're not at odds about the victims of these crimes, having successful prosecutions. I think the concern for us is, given the substantial evidence we've had previously, and certainly from the Lord President on behalf of all the judges, High Court judges bar one, is that this may be counterproductive to those very victims that we would share your huge concerns about. And Lord Gill moved on to talk about a review of all the rules of evidence, some of which you've said about the right to silence, and whether if we looked at all that, because he made it plain he didn't want to see corroboration as set in aspic, but to look at it all so that the difficulties you find as a prosecutor might be overcome in a different way. And I'd like your comments on that proposal that he had, because I think we would all wish to see successful prosecutions, but the concern would be that this is not going to achieve for those victims what you and I and everyone would wish in public.
Well, a couple of points in relation to that. Firstly, if, on the hypothesis that corroboration was abolished, how would the Crown approach its work? How would the Crown approach its decision-making and whether or not to take up a case? Now, in the two written submissions that have been placed before the committee, A distinction is drawn between corroborative evidence and supporting evidence. I'm sure it's a distinction that everyone here will understand. I would not, and prosecutors would not take up a case without any supporting evidence. But that is different than a legal requirement for corroboration. Of course you would want to look at supporting evidence, evidence which supports what the complainer, the victim, is saying in reaching a decision. And we would apply the reasonable prospect of success test, looking at issues of credibility and reliability. So I hope that gives some reassurance to the committee about that. But secondly, in relation to your wider review point, which I think was maybe the principal thrust of your question, look, I completely respect Lord Gill, as I do Lord Carloway, as I do all the judges in Scotland. They have a difficult job and they've got a view. But I've got a view as well, and the prosecutors have a view. And I read in the last couple of days Lord Carloway's review report. And it seemed to me that it was a major piece of work. It took a year. There was a review group, a reference group. There was 5 road shows. There were visits down south. There were visits to the continent. They spoke to experts. They visited the Criminal Cases Review Commission, Glasgow Sheriff Court, and various other matters. It's all in Lord Carloway's report. So it's an extensive piece of work, and this was his recommendation. And it's not his only recommendation. It's across a raft of areas. So my own personal view is that I don't think it's necessary to go down the road of, for example, a Royal Commission or having the SLC to look at it. But again, look, I respect other people's views, and if that's the view of Parliament, that's the view of the Scottish Government, and I'm quite happy to go along with it, and we'll contribute to any review. But just to reiterate, I don't think it's necessary given the extent to which the Carloway review its work.
I'll let other members pick up on whether they think Carloway's rule was thorough with regard to corroboration. I think that could be, if you forgive me, open to challenge. If other members want to pick up on it, I'll be very pleased. Alison, Margaret, Sandra and John Finn.
Right, thank you, Convener. Good morning. I absolutely agree no one should be beyond the reach of the justice system, and that we need to strive to do all that we can to help victims of rape and sexual assaults. But is it not the case that conviction rates are very poor across many jurisdictions and are not significantly different, for example, in England?
Are you talking about conviction rates for rape?
Yeah.
Well, I mean, it's well recognised that there are issues, and I think Elaine Murray hit on a number of the issues about public perceptions. A woman wearing a short skirt is asking for it. I mean, I completely disagree with that, but there is that kind of view out there, and it's very important that you counter that in the presentation of your case, and certainly through the National Sexual Crimes Unit. We've been using expert evidence in many of the, call them rape myths, to educate the jury as part of the trial process. That work will continue. The statistic is often quoted, I think it's 3% or 4% of allegations of rape reported to the police result in convictions. What I can say is that in relation to convictions in Scotland, in relation to the charges that are taken up, the conviction rate is running at about 48 to 50%. However, what I would say is, and I feel strongly about this, the justice system is not about conviction rates. The justice system is about delivering justice. And I have my concept of justice is it's justice to the accused and justice to the victim, justice to the public. So, conviction rate is a barometer of how you're doing, but it's not the be-all and end-all of matters.
So, it can be clear that you think that it's important for a victim to have their day in court, as it were, whether or not it's in the public interest to prosecute?
No, I think it's important in cases where there is supporting evidence, there is an account or an allegation which is capable of being regarded as credible and reliable by a jury. that there shouldn't be any barrier to justice for that victim in horrific allegations. I mean, rape's a horrific crime. And it seems to me that in those circumstances where you have evidence which is supported evidence which is capable of being regarded as credible and reliable, those are the circumstances in which a complainer should have access to justice.
You quoted in your introductory remarks that 2,803 domestic abuse cases weren't taken forward, and you said something like 13% of rape charges hadn't been taken forward because of corroboration, lack of corroboration. But you've also been quoted quite clearly as saying that there will need to be rules for sufficiency of evidence. So how many of those cases wouldn't have been taken forward even with, without corroboration, but because there wasn't sufficiency of evidence?
We've done shadow marking exercises to ascertain how, what the proportion of those cases would be taken up if we applied a reasonable prospect of conviction test where there was evidence which was supporting evidence. Katrina Dalrymple was in charge of that exercise, so if you don't mind, I'll just hand over to her and she'll give you the figures.
The answer you're going to give is in relation to the figures you gave earlier, or whether this is the earlier piece of work, the desktop work that was done for Lord Carloway?
This is an earlier piece of work.
So you're not comparing the same two things this morning?
No, the shadow
so I'm not sure that answers my question. I mean, it doesn't help me much at all.
I think the issue that's been raised by my colleague is, given the remark by the Lord Advocate that it was a thorough piece of work by Lord Carloway, and that would embrace corroboration as well, because we appreciate there's other issues which are far less contentious. I'm looking at paragraph 7231 of the Carloway report, which talks about cases that were looked at by the Procurator Fiscal Service, by two Procurators Fiscals, one I understand who was active and one who was retired, and pronouncements that were made in relation to the number of cases that would have gone to prosecution, number that have been successfully prosecuted. And I mean, it since transpires that this was work that was done over a 3-week period, and it's only done by two PFs, and that was one of the bases of the empirical results if we got rid of corroboration. I think that that's what my colleague's asking about.
Sorry,
rather than which you're entitled to bring as well, obviously, as a separate matter. But and I'll pass this to you if you wish to follow it up.
I'm well aware of that, and I do think that it was a very brisk and not very thorough desktop exercise. But yes. I'm referring to your evidence this morning, where you gave us figures and asked us to suggest that we would be shocked that 2,803 domestic abuse cases weren't taken forward because there was no corroborating evidence. But you're not able to tell me how many of those would have been knocked out with your new rules of sufficiency of evidence.
No,
and therefore,
we are.
Okay, we'll hear that. Yes.
It may be helpful if I explain the broad shadow marking exercise that the Procurator Fiscal Service have conducted, and thereafter explain how we have narrowed that down and done an additional exercise in relation to domestic abuse cases. The purpose of the exercise was to assess the impact of the abolition of the requirement for corroboration on the prosecution service. We consulted with statisticians, and we took a relevant and random selection of cases that were identified in the region of 950 cases that had been reported to the Fiscal Service. The statisticians were confident that the sample size chosen provided a plus-minus 5% accuracy. So the results are designed to have a 95% accuracy and confidence level within them. Now, you'll have to excuse me because I am not a statistician and I am a lawyer.
We might have one here.
I'm glad.
So if you get bamboozled, we'll get bamboozled.
The cases had been previously marked. They were real-life cases that had been reported to the Procurator Fiscal Service between October and November of 2012. We selected 6 present Procurators Fiscal. We conducted a selection process for these individuals. They were provided with draft guidance and the new prosecutorial test. The 6 people that were identified, we tried to replicate what would be a normal team within the Fiscal Service that would be making decisions on cases. So we had a broad range of experience. We had some people that were relatively recently qualified, perhaps not so ingrained in the whole corroboration mindset, and we had other individuals that had, in excess of 30 years' experience of working within Scottish criminal law. The 6 markers looked at about 160 cases each, and in order to avoid any contamination of decision, they were given access to the police report, and they were not aware at all of the initial case marking decision. So it was all done offline, so they didn't have access, they didn't know what happened to the case previously. There was no impact in relation to the forum, so where the case would be prosecuted, because ultimately the exercise was designed to assess the impact of whether more or less cases that would be prosecuted. The forum does not come into the equation when you're looking at the abolition of the requirement for corroboration. This exercise was conducted over, I think, the cases, there were 160 each that the prosecutors were given to do, and they were given their own time to do it. And then we conducted an analysis of the results. In essence, the impact applying the new prosecutorial test to the business that's been reported was that we saw in the mid-range of a 1% increase in summary cases, which is about 1,227 new cases reported. And in solemn, there was at the mid-range of 6% increase, which was an extra 721 cases. Now, you may ask me how that compares to Lord Carloway's exercise. It is kind of like comparing apples and pears, but we have managed to do a level of comparison. Annex A looked at 458 cases and I think an extra 141 sexual cases. The percentages that are quoted in that were the percentage of the cases that they looked at. And when you looked at Lord Carloway's figures and you looked at across the whole, you multiplied it out, so you looked at it across the whole business of all the solemn work. Lord Carloway's figures, our statistician worked out, within the range of around about demonstrating a 9% increase. So our shadow marking exercise that we conducted with 6 prosecutors who were identified and selected is not in any way inconsistent to Lord Carloway's exercise.
Just to clarify, was that
Yes.
9% being taken to court, but not...
9% increase in the solemn business taken to court.
Yes, but
yes.
Was there then any prediction
Yes.
put into that of how many would have been successful, which was the issue?
No, that's our job. That's a jury question. That's
Yes, it
not
is.
a job for the prosecutors to
But
decide.
in Lord
whether,
Carloway's review, he makes the
No.
predictions are made about how many they think would have been successful.
Bearing in mind that our test is based on a reasonable prospect of conviction, so we are making an assessment based on the credibility of the allegation that there was a reasonable prospect of conviction before we decided to mark that case for
It's a
prosecution.
very important piece of evidence. Could we have that in some
Yes,
form?
we have written to the Finance Committee because this information is in the financial memorandum, but we can certainly follow up with a letter to yourselves for ease
It's
of
in the
reference.
financial memorandum of the...
In the Criminal Justice Bill, yes.
Missed that out. I didn't see that one.
Yes.
My apologies.
It may be of assistance if I...
See that?
We were concerned. We have to obviously look at the impact of the business that's also reported to the Procurator Fiscal Service. And we needed to work with Police Service of Scotland to identify what increase in business is likely to be seen in the number of reports. And I'm sure the Police Service of Scotland will provide their own evidence in relation to the exercise that they conducted. But it may reassure the committee that the exercise that we conducted in tandem. We offered guidance to the police, as the Lord Advocate would, in relation to the reporting of cases to the Crown Office and Procurator Fiscal Service. In that exercise, the police conducted a similar sample size, and the increase in the number of reports was about 1.5%, which I think equates to another 3,720 cases being reported.
It's at page 44.
That's right.
Explanatory notes.
So you have to look at the increase in the number of the cases being received by the police, which was likely to be 3,720. Now, the way that the organisation is planning for this legislation, we thought 1.5% increase from the police was actually quite low. So what I did was I sent one of my team back out to the police station, and I asked them to review what it was that the police had decided to report in terms of the exercise. And it became apparent that in actual fact the police had made correct judgments in most of the cases, and there was very little in addition to that that we thought would meet the reporting test to the Crown Office and Procurator Fiscal Service. So in terms of the police exercise that was conducted, we are relatively confident in that as well. Ms McInnes, you followed on in relation to domestic abuse. The other exercise that we have conducted internally is looking at domestic abuse cases, because we were very aware of the access to justice and the barrier that is prevailing. We looked at an additional 328 cases that had been marked for no proceedings due to insufficient admissible evidence, and we applied the new prosecutorial test to them. Now, we thought that there would be an additional 1,000 domestic abuse cases per year that would be able to be prosecuted in light of our new prosecutorial test, which, when we look at the increase that we have demonstrated in the summary shadow marking of 12,1227, then it is clear that our assumption is that the majority of the increase in the cases that we are likely to take to court will be in the domestic abuse cases on the summary side of cases, and that is the evidence that we have to date in terms of the exercises that we've conducted. So I hope that's helpful.
Avoidance of doubt, would you just clarify the new prosecutorial test, exactly what that is? Because it might not just simply be without having corroboration. There's more to it, is there? So,
the test is...
just for the record. So.
It's a test which is applied in other jurisdictions. It's reasonable prospect of conviction, whether it's more likely or not that the evidence presented to a reasonable jury would result in a conviction. There are component parts of it, obviously.
No, I see.
To assess that.
Submission as well. Yes. Alison, do you want to follow on?
And just ask the Lord Advocate, when he first came to the view that corroboration needed to be abolished.
I've always thought it, but I've never said it because you know, I really worked in a system that had corroboration. I didn't think that at the time that really that there was much support for it. So I kept my own counsel. So no, I've always been of that particular view. It's not a recent conversion on the road to Damascus, but...
or road to the criminal justice bill either,
yes.
for that matter. Margaret, followed by Sandra, followed by John Finney, followed by Roderick.
Good morning.
Morning.
Could we tease out this other jurisdictions that formed the basis of the reasonable prospect of conviction? Other jurisdiction, what kind of factors were taken into account? What was applied?
Well, I think visited, spoke to senior prosecutors at CPS, England and Wales. We've also spoken to the DPP in the Republic of Ireland and beyond. I was at a recent conference, the HOPAC Heads of Prosecution Conference, where heads of prosecution in Commonwealth jurisdictions across the world. So we
specific, Lord Advocate.
Well,
what precisely was in their test that you looked at and applied to these cases?
Well, what we did was we looked at, what their test was and the component parts of that test. So if you're applying that test, reasonable prospect of conviction, what you'd be looking at the principal allegations. So you'd be looking at the complainer's version, her allegation, her account. What you'd be then doing is you'd be looking for factors which would tend to suggest that her or his account is a credible and reliable account. So you'd be assessing factors such as is there supporting evidence for that account, circumstantial evidence, what is the evidence against that particular account, what's the counterbalance if there is any. You would then sort of reach a view on the totality of the evidence. And in Scotland, we don't look at a sort of complainer victim-centric evidence. We look at the allegation itself, whether supporting evidence for the allegation. And if we consider that there is sufficient supporting evidence, independent supporting evidence for the allegation, then we'd reach the view that there was a reasonable prospect of conviction. So it's a whole load of factors. It depends on what the evidence is. It may be it's eyewitness evidence, it may be it's forensic evidence, it may be it's medical evidence. So it's very difficult to say in each, sort of give a generality across cases. It depends on facts and circumstances of each individual case. But what you're looking for is you're trying to ascertain on an objective assessment of the evidence as a whole whether there's a reasonable prospect of conviction. Then as part of the process, once you've on the hypothesis that you have reached the conclusion that there is a reasonable prospect of conviction, then you would apply what we call the public interest test. Is it in the public interest that you would raise proceedings? You would take into account various factors, such as the seriousness of the charge. You would take into account the antecedents of the person accused. You would take into account any mitigation apparent from the information before you as to whether or not that is in the public interest to raise proceedings. So that's how we go about it.
I'm still struggling to understand what it is that's going to be introduced by way of law of evidence, the nitty-gritty of it, quality of evidence or whatever, that's going to be different from the system just now that you saw from looking at the Northern Ireland system, the Welsh system, and the English system?
Well, it's a reasonable prospect.
Was I correct in saying it was based on looking at how it was done in England in the Carloway report and the two PFs that looked at the cases there?
No. In the English system in the Carloway report, that research that was done by the Procurator Fiscals, did they compare it with if it had been prosecuted under the English jurisdiction? No, what we needed to do was we needed to...
Could you answer that question, please?
I'll endeavour to answer it. What we're doing, or what we did, was we looked at what test...
No, I'm asking about Carloway just now specifically. We can go back to the research.
But the test didn't come from the Carloway report.
I know, but I'm asking you just now about the Carloway. You've mentioned other jurisdictions for this new test that you've done after the Carloway report test was found lacking. I'm asking now what the Carloway Fiscals research was based on. Was it the English system where there was no corroboration?
I think it was the English system, wasn't it?
Yes. Well, can I ask on that, were either of the two prosecutors, did they have any experience of the English system?
No, I don't think they did have experience of the English system, but they've got experience.
In your opinion, then, would it...
Okay. And then you can come back in, yes, Lord.
Certainly.
But they have experience as a prosecutor, many years' experience as a prosecutor, so they know how to apply a test, they know how to assess the evidence, they know how to look for evidence in support of an allegation, evidence against an allegation, and they know how to apply the public interest test.
Wouldn't a better way to have done it be to pass these cases over to prosecutors who were au fait with the English system and the experience of it and get their opinion? And similarly with the exercise you've just carried out, where you're looking at Wales, you're looking at Northern Ireland, you're looking at, wouldn't it have been better to pass these cases over to these jurisdictions and let them come back with independent and objective analysis from their experience, which must be better than taking the Scottish experience and trying to say, oh, well, we think this would have made a difference? Would that not have been a better way and more conclusive evidence?
No, I don't think it would. I mean, it's possible you could have done that. You could have sent the cases to CPS prosecutors. There's no doubt that could have been done. I would answer your question this way. This was very experienced prosecutors with years' experience. They know how to apply a test. They know how to analyse a case. They know what to look for. So I don't think that had it been passed, for example, to prosecutors down south, that the results would have been any different.
We beg to differ in that one. Lord Advocate, you are the Lord Advocate for the whole criminal justice system, for every accused. Today we've heard very startling, compelling and welcome evidence, I think, that there are unintended consequences from the abolition of corroboration. Today your remarks have been just about totally concentrated on the victims of sexual crimes. What about the other victims and the unintended consequences there? And my question to you is this. Given the weight of concern given the Lord Advocate's comments this morning, given corroboration, Lord President, Lord Gill's evidence this morning, given corroboration hasn't just stood still, it's changed over the years. We've got the wisdom of the institutional writers, we've got court practice during the years, we've got this coming down and being something, quite frankly, I think we should be proud of in Scotland. Does it give you any pause for thought that perhaps you might be wrong, that there might be another way other than abolishing corroboration that could be looked at to help the victims of sexual abuse and to ensure, paramount, that the accused right to be presumed innocent isn't compromised, we don't have more miscarriages of justice, and that we have a better system for everyone?
Well, look, I'm not saying that I'm always right. I fully accept that other people may have a different view, other people may be right and I'm wrong. I don't know. My view is that I think I'm right. You raise other alternatives, other possibilities. For example, I think Lord Hope was asked in a recent article in the Hollywood magazine whether or not you could relax corroboration for the category of case which I've been talking about, sexual offending, sexual abuse and domestic abuse. His view was that that shouldn't take place. I think Lord Gill was also asked a similar question and he said it wouldn't be appropriate. I agree with their views on that. I've heard you speak about the possibility of developing the law of evidence or corroboration in relation to that. What I would say about that is that we have over the years developed in relation to Murov, for example, in the Murov case itself, 4 years of a gap in time between two allegations was held to be insufficient for the application of the Murov case. Recently had a case where we argued generational abuse and the court applied a gap of about 13 years in applying Murov. We've greater corroborating lesser. We've argued that an attempt corroborates a completed act. So prosecutors, it seems to me, have been pretty creative in legal arguments to try and place cases before the court. But my point is that the law of evidence has a limit. This is a legal requirement. It's evidence of two independent sources, both that the crime was committed and that the accused is a perpetrator, and the crucial facts of the case, and you can never get past that if you have the requirement for corroboration. But just in relation to that, can I just tell you about what the effect of corroboration has? You need to corroborate the taking of buccal swabs from alleged offenders, so it's 2 police officers to take that. You need to corroborate the taking of intimate swabs from a complainer in a rape case, maybe a child, injuries to sexual parts. You need to corroborate.
No, I just let Lord Advocate finish this, and then you've plenty of time. Lord Advocate.
You need to corroborate that children, what appear to be the case in child pornography, are actually under the age of 16. That has to be done by 2 witnesses. You need to corroborate your forensic analysis. So 2 forensic scientists are having to speak to the forensic or the results of the forensic examination. Transmission of samples are being required to be corroborated, and it seemed to me that this is completely unnecessary. So that's where I come from.
So we seem to be back to sexual offences again. I'm looking at the whole system, every accused that comes before into the criminal justice system. My question is, would you be prepared to at least look at a third way where corroboration is retained? And we're looking at all aspects of the law of evidence. You've mentioned this need for 2 witnesses. If it comes down to the credibility of a witness, then vulnerable witnesses who at present can give evidence via video link or special measures, the likelihood is they will be required to attend because it's important to judge the credibility. It's all important then. That's perhaps something, a downside to the other things that you say are positive. We're looking at this within the space of, what, a couple of hours this morning? We've spent the time on corroboration and a huge bill. Wouldn't it be more sensible, given the importance of getting this right, to take corroboration out of this bill, to look at a third possibility as well as retention and abolition, the third possibility of retaining and improving, and having a commission to really properly hammer this out so that we're sure that we've been transparent, justice has seemed to be done, and the right answers have been decided upon. 2
points. I think you mentioned evidence, alternative means of giving evidence by, for example, CCTV, and the effect the abolition of corroboration may have on that. They're required to, rather than give evidence by a remote site, they have to come to court to give evidence. And you use the example about, assessing, a witness by seeing them. I don't think that giving evidence by CCTV or remote link in any way affects the assessment of credibility and reliability. And I don't think, in my humble opinion, that should be or would be the effect of the abolition of corroboration. To go back to your principal question about, another way, another more detailed look at it, you may have in mind a Royal Commission, or the SLC may look at it. Look, I've heard all the views. I respect all your views. Ultimately, that decision is one for the Scottish Parliament, not for me. I'm only giving you my own view on it. I don't think, given the extent of the work done by Lord Carloway in his review, that it's necessary.
Can I just say one further thing? Given the pressure on budgets and Police Scotland and various people, can you micromanage the kind of situation that Lord Gill said could very possibly happen, where if you don't need to establish corroboration, you don't go that extra mile to incur the costs of looking for that corroboration, and the effect of that in unsuccessful convictions?
Well, I'd answer it this way. I think I touched on it in my opening remarks. The police are under a common law duty to fully investigate a case. The case of Smith sets that out, their duties. We are under, as prosecutors and police, under a duty in the European Convention of Human Rights to properly and fully investigate cases and bring forward all relevant evidence. We're also under a duty on our disclosure obligations to make sure that cases are properly investigated, and any evidence which is in favour of or adverse to an accused person is properly disclosed. Prosecutors are under duties to place, make sure that the trial is conducted fairly. The notion that you wouldn't want to bring the strongest case that you could to court is something which is alien to me. But one other point is that the work done by police and prosecutors can sometimes result in an accused person being exonerated, not being taken to court, and that is perhaps sometimes overlooked. And I have plenty of examples of good investigative work carried out by the police and procurators fiscal, resulting in no prosecution at all. I can give you a very serious example of that way back in the early 2000s, where a number of people were accused of terrorist offences in Scotland. They'd been arrested living in a flat in Easter Road. It was just before the Hogmanay celebrations in Edinburgh, and there was very sinister productions, exhibits which had been found in this flat. One which looked like a diagram of where you would place a bomb in Jenner's and the Edinburgh Woolen Mill in Princes Street. I know for a fact that the police, with support from the Procurator Fiscal, traced all the occupants of that flat, including one to Perth, Australia, and he was spoken to, and he said, yeah, that's my work. I work for Glenmorangie Whisky Company, and actually I prepared that diagram, and that was where I was having a whisky display in Jenner's and Edinburgh Woolen Mill. And as a result of that investigation, the case went nowhere, and quite properly wasn't taken up. And that, what I'm saying is, that's just an example of the determination, the I suppose, the morality, the right thing to do to fully investigate a case which could exonerate someone accused of very, very serious offences. What I'm saying to answer your question direct is no, not under my watch, and I suspect not under any future Lord Advocates or Chief Constables of Scotland. You'd always want to bring the best case that you can to court.
But the point being, you can't micromanage every case.
Well, I mean,
and there will be pressures, there is no doubt about that. We know there will be pressures. And if you don't need corroboration, then I rest my case.
She's rested her case. That's good, because I've got other people waiting to ask a question. But you did raise examples of where it would appear to me and perhaps other members of the committee that corroboration is over the top when you need two police officers to speak to something or whatever. Is there not a way that under a review procedure of this we could look at the requirement for corroboration in those particular instances to be dispensed with unless challenged? I mean, I'm not an expert, but it does seem that you've made a fair case there that that's too much. But we haven't been able to look at that, and I suspect that Lord Carloway didn't have time to look at that because it's getting rid of corroboration across the piece. Instead of looking at that in particular, would that not form part? Could that not be useful to perform part of some kind of review?
Well, it may be useful.
In the whole of the evidence.
I don't demur from that suggestion, but of course at the time that you're carrying out this work, corroborating the taking of samples, you don't know at that time whether or not you're going to require to lead corroborated evidence. I'll give you an example. Say in a homicide, you have to identify the body. So the way it happens in Scotland is family members are having to attend at a mortuary and thankfully look at a screen and identify their loved one prior to a post-mortem examination. Nothing could be more horrendous, I would suggest, than having to do that. It has to be corroborated. In the Criminal Procedure Scotland Act, it says that if you don't challenge the identification of the deceased referred to in the post-mortem report within 6 days of the trial, then that evidence is presumed and you don't need to lead the evidence of identification. But of course, at the time that you're requiring the identification, you don't know whether or not there's going to be a challenge 6 days from the trial. So police officers in those circumstances will require a double identification to comply with the rule for corroboration. Yes, it could be looked at. It could be looked at. Again, what I'm doing is I'm giving you examples of in practice.
It's very helpful, but having raised the issue of that, we've moved from corroborating evidence in court, say, to what's corroborated in gathering evidence and transferring and transmitting evidence, moving it from one place to another. And I think I simply wanted you to follow up and see whether that could form part of any review of looking into what does require and what doesn't require corroboration in court.
Well, of course
it could.
Of course it could.
Thank you, thank you. Sandra, John Finney, Roderick, please.
Thank you very much, Convener. Good morning. I was going to ask you about the requirements and the technical burdens, but you've already answered that particular question. I've no doubt around this table we all want to see justice for victims. We may go about it in a different way, but I've no doubt we do definitely. Certainly, yes, you're looking at the court, cases, etc., prosecution, defence, but we've got to remember under this there are victims who do want access to justice. And I do, 2,803 domestic abuse and 170, rape cases, not even, going to court, basically. That, to me, is a dereliction of justice for the victims that's there. And when you look at the points that's been brought up of the statistics by Ms Dalrymple, you're talking about 1%, 7% increase in these would go to court. And I think it's something that we would all welcome. It's how we get to that particular point, as you say, in regards to corroboration. Now, obviously, Lord Gill had given his evidence and very much of the view that we shouldn't get rid of corroboration, very much opposed, but it was mostly the judiciary which was opposed to it. I mean, I broached the question regarding guidelines, and basically we're looking at the Criminal Justice Bill in the round. Lord Gill seemed to say that obviously corroboration should come out of that, and other aspects of the Criminal Justice Bill should be looked at again, not proven and that type of thing. I just wanted, your comments on Lord Gill's comments in regards to that, his opening remarks to that, and also the fact that whilst we've had, members here talk about, evidence going forward to prosecution, and judges, as Elaine had, not judges, as Elaine had mentioned about juries, I would just ask what your comment would be, and if corroboration is abolished and more of these cases go to court and access to justice is opened up through time, through time of more cases going through juries, then their attitude may change, their social attitude may change, and we would see more justice done for victims.
Well, I think that's a very good point, and social attitudes do change over time. I mean, I frequently give the example of the social attitude to drink driving in the 1960s in comparison to what it is now, racial abuse in the 70s in comparison to what it is now. There have been studies across the world into what we call jury myths about how jurors across the world see and view certain evidence, such as delayed reporting, such as a lack of physical resistance, such as the way a woman is dressed. That is something which prosecutors and police have to recognise, and hopefully through time that the public, or some members of the public, because I'm not saying that all members of the public subscribe to that, but there's a proportion, some members of the public may change their attitudes, and I think that would be a good thing. We recognise that. I think I mentioned earlier that we do, in certain cases, lead expert evidence to say that, for example, delayed reporting is normative behaviour, and I think that's a good thing.
Chair, could I?
Of course.
Well, thank you very much.
The only thing I'd say is bear in mind we've got another, I don't want to curtail us, and I'm certainly having the other people who are down to ask questions, but that we've got another panel and they have to be away by 12:45. And just alert you to that. So
thank you very
short
much.
Questions if possible.
Yeah. Thank you very much, Chair. The other question I was going to ask was obviously the corroborative evidence, and this is what it all comes down to. And I did ask Lord Gill regarding that, and he mentioned about the prosecution. But I would also say in regards to the defence, if you have a case and there's two witnesses, it could be someone's friend on behalf of the defence, not necessarily on behalf of the victim. They may not be telling the truth. So you still have these two witnesses. And if you've only got the two people there and you have corroborative evidence, you've made it quite plain that the police and your procurator fiscals do their utmost to get that evidence. What I'm saying is, and I'm probably wrong in this, and I'm not accusing anyone of this at all, but on the defence side, is it more likely that the defence, the accused, wouldn't necessarily push so hard for the case to go ahead because there was only two people there without looking at the actual corroborative evidence which could be obtained? I'm not talking about the prosecution of the victim. I'm talking about the accused.
I'm completely lost.
Maybe everybody's lost, but in my head,
I'm completely lost. I didn't.
Well, let me answer it this way.
Well, you're not lost. That's good, because I understand. I didn't understand the question. I'll be frank.
I'm talking from the victim's point of view.
Well, I'll answer it from the accused point of view. You don't need accused is not required to corroborate anything.
Well, that's
and that's a rule of law, and it's a good rule of law. So I don't have a problem with that. And let me say that. In relation to defence counsel solicitors, I think they do a very good job in Scotland, and in order to have a fair trial process, it requires counsel solicitors to be at the top of their game to challenge the evidence and test the evidence. In my experience, in many years in the criminal justice system, is that happens, and that's part of the suite of protections to ensure a fair trial, that you have legal representation and that you have robust testing of the evidence. You have the ability of the defence to carry out their own investigations, to lead their own witnesses if they want, to make a statement during interview if they want on legal advice, and whether or not they wish to give evidence. That's a part of the suite of legal protections. There's many more. So to answer your question, you don't need to corroborate anything. That's a fundamental rule of law in Scotland.
John Finney.
Lord Advocate, you alluded to the Cadder case, and if I noted you correctly, you said you weren't critical of the Cadder case. You also outlined for us that as a result of that, that one of the three essential requirements to corroborate, namely that penetration is lost. It's been suggested by a number of people that the removal of corroboration is a rebalancing of CADA. Would you like to comment on that, and is that your particular view or the rationale for your support for it?
Yes, I believe that, and it's not only my view, it's Lord Rogers' view, and he was one of the justices, Supreme Court justices in CADA, and if you read his judgment, he said that he recognised that as a result of the CADA judgment, the balance would be tilted against the police and prosecution, and the implication of that being that there may need to be a rebalancing of that to ensure justice to both the victim and justice to the accused, because any criminal justice system is a balance. It's checks and balances to ensure that the guilty are convicted and the innocent are acquitted. And part of the argument in CADA was that there was a whole suite of balances which included corroboration, and against that you had no right of access to solicitors, so it was a delicate balance. And as soon as you disturb that and make a right of access to a solicitor, then you're disturbing that delicate balance, and there would need to be a rebalancing exercise. So I agree with Lord Roger in that. I've got the utmost respect for him. I worked for him for many years. So that's, I agree with it.
We've heard a lot of use of the term the public interest. Could you rank for me in terms of 1, 2, 3, the accused's interest, the public interest and the victim's interest? And I've listed them alphabetically for the avoidance of any.
I don't think it's a league table, really. I think that they're all sort of part of the consideration of the public interest. I mean, I'll give you a very extreme example of where how you would determine the public interest. Say, for example, you have a woman, a widow, who's recently lost her husband. She's 65. She's never been in trouble before in her life, and suddenly she's in, Asda, and she shoplifts, and it's a cry for help more than anything. Now, I would suggest that even if it's a rock-solid evidential case, which, if you place before a court, would be bound to result in a conviction, it would be in the public interest, having regard to the accused's interest overall and the nature of the crime. It wouldn't be in the public interest to prosecute that woman. So it's all those kind of considerations that are in the mix.
I appreciate at the margins of extremity either end, you can come up with examples. With a standard circumstance of an uncorroborated allegation of crime, of rape or a sexual offence, where would the ranking go in that instance, please? Well,
I don't think there would be, in the sense of a ranking. I think it would be all part of the consideration. I mean, if you're talking about a charge of rape and you had sufficient, credible and reliable evidence to place that case before a jury, given the seriousness of it, I think it would be inevitable that you would take proceedings, because it would be in the public interest to take proceedings.
You've already acknowledged there is a rebalancing as regards the accused. The accused, as a result of CADA, has entitlement to solicitor, which will normally result in them not saying something, which would have provided some of the evidence which would have supported you prosecuting in the past. You're saying that's now removed.
So let me answer it with, or try and answer it with the circumstances of a woman who delays reporting counterintuitive behaviour. So there's no forensic opportunities to corroborate.
Example one in your case there.
Yeah. But there's supporting evidence. There's very recent distress. There's powerful recent distress. It may be she says that her pants were ripped, and lo and behold, she's retained her pants. They are ripped, and you have forensic evidence to say, for example, that that is consistent with her account. You can never fill in the gap there, because there wouldn't be corroboration of penetration. So no matter what the quality and quantity of the supporting evidence was in those circumstances, you would never have sufficient evidence to take up the allegation of rape.
So where, apart from a suggestion from the accused that it was a consensual act, would your corroboration of penetration ordinarily come from then?
Well, it would ordinarily come from the forensic evidence if you had that opportunity. If not, then it would be very difficult in most cases, I would suggest, to obtain corroboration. It may be, for example, that...
Example 1, for instance, is a statement of a fact rather than a summary of the outcome of the particular set of circumstances narrated there.
Sorry, I don't appreciate the point.
Right, okay. Well, if I tell you that the outcome is, as there is no corroboration of penetration, we cannot prosecute the charge of rape.
That's the case.
That's a statement of fact in any case.
Yes, but what I'm saying is if you abolish corroboration, there's supporting evidence there that would require you to take up that case. And then it's a matter for the jury and whether or not, having tested that evidence, the jury find that that case is proved beyond reasonable doubt. So that's an example of a case where we can't take up at present with the rule requiring corroboration. But if you abolish corroboration, it's a type of case which we would take up because there's supporting evidence of the complainant's account.
The information outlined there doesn't say whether there was a medical examination, a delayed medical examination, for instance.
A delayed medical examination wouldn't give you the evidence to identify or corroborate the identification of the perpetrator.
Right, okay, we'll move on. When you talk about the reasonable prospects of conviction, in the written evidence you give us, you cite a Canadian case, Boucher perhaps versus the Queen 1954, which says, it cannot be overemphasised that the purpose of a criminal prosecution is not to obtain a conviction. Does that conflict with anything you've said before, namely that you would only proceed if there's a reasonable prospect of conviction?
No, I don't think it is. Look, if a person is innocent, I want them to be found innocent. I don't want a miscarriage of justice. I don't want someone wrongly convicted. In assessing whether or not there's a reasonable prospect of conviction, that's the gateway test. And what you're doing is you're using that to determine whether or not the case is to be indicted. So in those circumstances, the case is put before the court, properly tested, and ultimately it's for the jury. What I'm saying is that the requirement for corroboration has an effect because the gates are shut for many victims of rape, sexual abuse and domestic abuse and other crimes, predominantly those categories of criminal offender.
Thank you. Lord Advocate, can I ask you about false allegations? Because, again, in your written evidence, you provide what would be very reassuring commentary if you were a police officer, a teacher, a social worker, a health professional or a prison officer, and that is about the depth of scrutiny that goes in about false accusations. What if you were a joiner, a van driver, a shop worker, an unemployed youth?
Well, I think, to answer your question, there's a recognition that, I suppose, teachers, professionals in those circumstances, including police officers, in a perhaps more vulnerable position in relation to false allegations, and that has to be recognised. So there's procedures in place currently for example, allegations against teachers before a decision can be taken whether or not to prosecute has to be referred to Crown Counsel, so that there's a thorough look at the case itself. And that's the same with police officers itself. But I would like to think that procurators fiscal throughout the country apply their common sense. They're trained, they can analyse a case, they can look at the evidence, they can look for any indications of false allegation, and I suppose ultimately at the end of the day this evidence will be rigorously tested before a court of law if proceedings are raised. And that is the same for a joiner as it is for a teacher, as it is for a police officer.
Don't look concerned, John. What I'm going to say is, because we must move on to the next item, I'm going to allow, I've discussed, we have an opportunity if required. I'm going to get Roddy in because he's sat there waiting, but MD who's not been in.
Included anyway.
That's excellent, but just don't want MD to worry that I'm curtailing this, because it's very, very important analysis of it, that we may at some point, Lord Advocate, invite you back if we've got other questions. The same might be true of Lord Gill or other witnesses in this particular issue. So don't feel that I'm suppressing debate on this and questions, but I do want to have the last question from Roderick. Alison, I know you're in the list, but we can come back to things if that's all right. Roderick.
Morning, Lord Advocate. I'd just like to follow through on the differences the new prosecutorial tests will make as opposed to the existing test. Obviously, I've read your submission, paragraph 15. In terms of the qualitative assessment, could you just clarify the difference the new test will make as opposed to current practice?
Well, current practice doesn't have this test, so we'll be applying this test across all consideration of criminal allegations. Currently, we have really there's a focus, in my view, an undue focus on quantity, because if you're looking at a case, and the first thing you look at, really your primary focus is on quantity. Is there corroborated evidence? If the answer to that is yes, currently we'll then look at credibility and reliability, but there's no test of reasonable prospect of conviction which is applied currently by prosecutors. And what I'm saying, to try and give reassurance to the committee and the Parliament, if it is the Parliament's choice to abolish corroboration, that we will apply a reasonable prospect of conviction test where there is supporting evidence for an allegation, and I hope that that would give reassurance to this committee and the Parliament also.
Yeah, but just to clarify, currently may not be a formal test, but you do consider credibility and reliability.
We do, but we don't consider it against a test, reasonable prospect of conviction.
Okay, just about with you, I think. Distress is a comparatively, the evidence of victims' distress is a comparatively recent addition to the corroboration tool. Could you just explain to the committee some of the difficulties that gives rise to?
What evidential value recent distress has?
Yeah, and explain well, obviously that's an addition to kind of corroboration as it was in kind of centuries gone by, and how that operates in practice and the difference it causes.
Well, recent distress is obviously a piece of evidence, but in relation to what it corroborates, in an unforced rape, it only corroborates the lack of consent. It doesn't corroborate penetration, doesn't corroborate mens rea. So it'll only take you some distance along the three crucial facts that you have to consider, or you have to corroborate in a charge of rape. And of course, there's conditions to distress. It has to be recent. It's got to be displayed to the first natural confidant. There's a raft of case law as to the gap in time between the allegation and when it's displayed as to whether it can be taken account of by the jury. But just come back to the example, I suppose the effect of it is it doesn't corroborate penetration. It can't be used for that effect.
It's helpful. My final point in view of the time is just in relation to the two submissions from the Crown. There's no comment on kind of what might be described as safeguards if corroboration is removed. Is that because you didn't want to get drawn into that debate, or?
Yes, in the sense that, for example, a not proven verdict, whether or not that should be abolished, I think that's the Scottish Government's announced that's going to be looked at by the Scottish Law Commission, so I welcome that. Don't have a problem with that. There are many safeguards in the trial process. I've alluded to some of them today. I didn't think we were being asked about that particular additional safeguards. But if it's something that the committee wishes further information on, we can respond in writing.
I'm quite interested in it, but in view of the time, I'm quite happy to leave it there for the moment.
You can write and follow it up. That would be very helpful. Yeah. I'm going to bring this session to an end simply as we must go on to other business. I thank you very much for your evidence, Lord Advocate and Ms Dalrymple, and I'll suspend for 5 minutes to allow the tables to be set up for, it is cool in here, to be set up for a round table. Hot soup, please. Suspend.